Dean.
Move that the question be now put.
Moana Mackie.
Thank you, Mr Chair, and I still have a number of amendments in my name that I've yet to be given the opportunity to speak to, so I'm grateful for the call. I think a general concern we have about Part 2 of the bill is that it seems that there are many more barriers to people submitting on applications than there are to the applicants. It seems, and as we come into Part 3, we'll discuss the removal of appeals to the Environment Court. But there's that general tone throughout Part 2 of the bill, and the Minister's SOP takes those a little bit further. And my colleague's just been speaking on my SOP in relation to mediation. In fact, the Minister doesn't need to support the SOP, she just needs to withdraw her amendment in hindsight. But we were trying to put in the SOP to outlay what our concerns were, and I've had a conversation with the Minister about that, and I appreciate that we agree to disagree on this matter. But we do feel that while I certainly appreciate the concerns the Minister has about wanting to facilitate these processes and make them move smoothly, we would have liked a bit of a protection in there to say that this can't be used to try and undermine the mediation process while that's happening at the same time as the hearing. That the EPA could benefit from having that information in front of it, and we would have liked to have seen some words around where the discussions that are occurring at mediation don't have a material impact on the hearing, where things can be taken offline, like people with existing interests might just need to have a discussion with the applicant, and that can be done outside the hearing. Absolutely, but I think, would have liked to have seen that protection put into wording. Now, I don't believe that the EPA are going to try and abuse this power. That's a reality. But I always like to have these belts and braces so that people can feel that their rights are not going to be usurped. There's some protection there. I don't believe for a second that the EPA is going to suggest that Greenpeace and Petrobras go through a mediation process. I appreciate this will probably be for small technical things, and I think that's just where we would have liked to have seen that protection put into law, but I appreciate the Minister's decided not to support that. I do have another amendment in my name that I hope the Minister would take a call on, which is around the time limit for the hearing. In clause 52A of the SOP, the Minister's SOP, it says the hearing must be completed not later than 40 working days after the first day of the hearing. Now that seems very reasonable, because I doubt many hearings are going to go for longer than that. And I have an SOP in an amendment in my name which explains that where there are exceptional circumstances, where you have a particularly complicated case, for example, where something arises and the EPA may need to call in an international expert, it may be hard to get that person in, whether we can be clear that actually the 40 days have to be, is it the 40 days is 40 days of hearings, not just 40 consecutive days or 40 working days. It's 40 working days. I know that's what it is in the bill. But just to clarify that in exceptional circumstances, and I know offline the Minister has indicated to me that is somewhere else in the bill. It would be useful if she could tell me where that is, and then we can...
147.
Sorry?
147
and then what part is that in? 3. Okay, well then we'll have a look at that before we get to Part 3, but we are concerned, and again it comes back to, I think, the conversation we had in Part 1 or Part 1A about just making that clear, that when we were talking about the incomplete clause 42, which is around incomplete applications, we would have liked to have seen that made clear, that you can't just go through that over and over again. And I think it's the same here, whereas it wouldn't hurt to make it clear in this clause that even though there is a time limit of 40 days in exceptional circumstances where we want to make sure that we have the best decision-making processes and the best information available to the EPA, that they are in fact able to extend that hearing beyond 40 days. But I'll have a look at that when we come to Part 4 of the bill. Now, there are my colleague Grant Robertson talked about the amendment that I have in my name around adaptive management. That is a real concern. We had a big discussion about it at Select Committee. Obviously, it was another area. It was along the same kind of lines as the precautionary approach, where some people had big concerns about the use of adaptive management, but we really do feel that having some language in there around where the effects are likely to be very serious or irreversible, adaptive management is just simply not appropriate. And for most of the things that occur in the exclusive economic zone, and we focus in deeply on oil and gas exploration, but this covers a much broader variety of activities. And in fact, I suspect that most of the marine consents issued under this legislation will relate to, Mr Chair, thank you, will relate to laying of pipelines, fibre optic cable, things like that. And there may be other areas where, in fact, adaptive management can be used and is appropriate, but where the effects on the environment especially are likely to be irreversible, where then in fact that undermines the whole concept of adaptive management, because it means you can't pull it back. Adaptive management is about allowing something to go ahead and tweaking it as you go. When it comes to an irreversible change to the environment, there's no tweaking that can happen beyond that. And so I would, again, really urge the Minister to think seriously about how adaptive management has been laid out in the bill. Now, the Minister also has, this is a much smaller issue, but I do want to mention it because it does occur throughout the legislation, which is Clause 60A. And we're seeing this throughout the bill, and that's in the information principles. We're seeing this throughout the bill whenever there's any kind of guidance around what information the EPA needs to consider when they're making an application. And we notice in the Minister's SOP there's been a real narrowing down, so that in many cases it can only be information that they've sought. So if someone has provided them previously with some information which might be relevant, which might indicate environmental impacts that may well be serious or irreversible, and where they may be concerned that the EPA has made a decision which goes against that advice that's been provided in that paper, unless the EPA themselves have sought that paper, then they don't have to consider it. And I think in terms of the EPA developing up their knowledge base, to suddenly say that, no, the only things that need to be considered in legislation are things that the EPA have actively sought out themselves. And while we welcome other amendments the Minister has made to require them to consider the input of the Māori Advisory Council, and we see it in Clause 59.4b as well, only the information that's been sought. Suddenly we're narrowing down what they need to consider. And I'm not quite sure why that is. The Minister says it's not. It'd be useful to know what that is. It's one of these things where you think it could have a large material impact on the processes and the ability for people to challenge the EPA, where they really feel that they provided some very strong evidence and the evidence wasn't even considered at all because it now falls outside of the requirements of the EPA to do that. So that's about all I have for my contribution on part two. I do just want to briefly respond to the comments made by Nick Smith when he gave his somewhat wide-ranging speech on part two of the piece of legislation, which is that I think that any political party that hasn't taken stock of their policies in this area post the Gulf of Mexico and post Arena are not taking the issue seriously enough and are being neglectful in their duties as a parliamentarian. Certainly, both those events were game changers. I went to a public meeting in Whakatane around the arena where there was real anger, and the Honourable Dr Nick Smith didn't want to answer a lot of the questions that people were having around the application off the coast off the east coast with Petrobras. They were game changers. Well, Hekia Parata can pull faces at me. We would have loved to have seen her during her time as Minister of Energy on the East Coast. Well, you weren't happy to answer questions when you were Minister of Energy. That's a problem, Ms Parata. We would have loved to have had the Minister at many meetings up there. I know it's your home area. That's why we were so disappointed. But, I mean, the point being, following up from the comments the Honourable Dr Nick Smith made, is yes, we did a lot of the stuff when we were in government, but we took stock and said, really, have we got those bottom lines right? Are we addressing the concerns of the public? And this legislation, which started its life under a Labor government, but which is much more environmentally stringent, we don't believe simply meets that test. And so Nick Smith can attack us for that. But the reality is that they were game changers. We saw what happens when oil gets in the water in the Eastern Bay of Plenty and the Bay of Plenty, and the public have concerns, and they have every right to expect that their representatives in Parliament will take those concerns on board, learn from them. I guess that's the difference between being in a progressive party and being in a party that's constantly about the status quo and with no new ideas, Mr Chair. So I'd welcome the Minister's comments on some of those parts in the bill, but certainly on the issue of the time limit for the hearing, we'll get to it when we come to part four.
I call Nikki Wagner.
Thank you, Mr Speaker. I move that the question be now put.
I call Eugenie Sage.
Thank you.